In that 120-page judgment, the Court of Appeal was especially scathing about how legislators crafted the 2023 Finance Act. They said, and I'm quoting them here, insulating Parliament from the obligation to give justifications for rejecting the views of the public is the surest way of rendering public participation illusory, a mere formality, or a public relations exercise. End of quote. But what precedent does this judgment set, especially after the vehement rejection of tax hikes in the 2024 finance bill? That's why I started my conversation with Nikhil Hira. He's a partner at the tax advisory firm Cody Africa.
And I think that was the critical element of the ruling last night in terms of what is public participation. And it can't simply be that we write in and say, this is our view, and we're not told whether it's accepted, not accepted, why not, why yes. And I think that's what the thrust of the whole ruling was.
Indeed, and it was actually kind of interesting also to see what the Court of Appeal was saying about amendments that are being introduced during the third reading of the bill. And the argument that I believe some of the plaintiffs were making was that, look, a lot of the mischief in the lawmaking process happens there, because that's when we start to see a lot of the contentious clauses already being brought in well after the public participation part of the entire process has already been concluded.
And of course, that means public participation has failed, because you're now bringing in legislation which you're not asking for input from the public from. And I think that was another key aspect of the ruling, and indeed of the petition, to say, if you start sneaking things in, then where's the public's role in all this?
Indeed, and that's a whole other conversation given the quality of responses that we often see in parliamentary committee reports. But I want to move it forward. The Finance Ministry will certainly appeal this decision. I haven't seen the documentation on that yet, but I'm willing to bet that they certainly will. But in the interim, for companies, for example, like East African breweries, which would have to remit taxes within a 24-hour cycle, given the provisions that were in this act. Now that that 2023 Finance Act has been nullified, how should they be thinking about applying tax rates during the month of August?
The ruling has said that Finance Act 2023 is null and void. It's as though it never existed. So all the provisions that were introduced in it, other than housing levy, which was dealt with separately because it was subject to a separate court case earlier, have effectively disappeared. So you talked about breweries paying taxes every 24 hours. Well, we now revert back to the 20th of the following month. We talked about additional PAYE, 32.5%, 35%. We revert back to 30%. Residential rental income, here's the bad news. It was at 10%, it came down to 7.5%. It'll go back up to 10 now. But the point is that how does administratively, how will the Kenya Revenue Authority cope with this? Because all their back end of the ITAX system will need to be amended to take it back from what they put in for Finance Act 2023 to back where it was for Finance Act 2022. I suppose the advantage of it having happened on the first of the month is that they have literally 24, 25 days in which to make the corrections and allow taxpayers to go back to Finance Act 2022.
And what happens in the hypothetical scenario where, say, government appeals and the Court of Appeal then, perhaps for the sake of argument, the Court of Appeal of the Supreme Court then says, okay, we put a stay on the judgment. What are the tax obligations that we're facing in that sort of instance? Are we still proceeding with the tax policies under the 2023 Finance Act, or we're going back to 2022?
No, my view, and as you know, Ram, I'm not a lawyer, but a stay on the judgment means that we're back to where we started. It doesn't mean that it can't come back as being null and void, but so long as the stay, the existing law will continue. So we will continue then to pay, to do our, breweries will do their 24-hour payments. We'll get taxed at 32.5%, 35%. Rental income will be at 7.5%. But you make all these payments, and then supposing the Supreme Court, however far down the line, whether it's this year or next year after, says, no, we agree with what the Court of Appeal said, then we're not going to get this money back, which the Court of Appeal was very clear about, that what is done, you can't have the tax back. And in any event, for indirect taxes, there's really no mechanism for me as an individual, having bought my bottle of Tusker, to go back and say, please revert the excess excise duty, or for my litre of fuel when they double the VAT, to say, please give me the 8% back. So I think the Court of Appeal took the view that let's not go there. You've paid it, it's done, dusted, forget it. But going forward, assuming the ruling stays in place, we'll revert back to Finance Act 2022.